Good afternoon, students. Today is Monday, 7 March 2022. Today will be our second of 3 days on the essay by Bonnie Steinbock entitled Drunk Driving. The second exam is 24 days from today. It's on the 31st of March. Make sure you get it on your calendar. As for postings, if you look at Canvas, you'll see that I've posted a number of items for this part of the course. Besides the article by Steinbock itself, I have posted my lecture notes on this article, which you can follow along on. I posted a taxonomy of homicide. Here's my copy of that. So you should have that printed out and have it in front of you as you watch my video. I posted an article from Newsweek magazine from many years ago, 40 years ago, entitled The War Against Drunk Drivers. It's an article that Steinbock herself cites in her article. I posted, for your information, a handout called Blood Alcohol Content Charts, and it shows how many drinks it takes for an average man or woman to get a blood alcohol content of a certain type. You may be surprised at how little alcohol it takes for you to fall within the legally prohibited range. So I post that only for your own information. I also posted as an optional reading the Texas Penal Code. A year or so ago, I went through the Texas Penal Code and I identified all of the different punishments, the felonies and misdemeanors, and I put down also some exemplary crimes so that you can see which crimes go in which categories. Now that's purely optional. You can ignore it altogether if you'd like. I won't ask any questions about it, but you may also find it interesting to look at. And finally, I posted a case from 1957, coincidentally the year I was born. The case is from Tennessee. It's entitled Edwards versus State. It's quite short. It's optional reading. You don't have to read it, but you may find it interesting to read an actual case in which the Supreme Court of Tennessee ruled that drunk driving can be second-degree murder. It can be what Steinbock calls depraved heart murder. So it's a case that Steinbock herself does not cite, but she might well have, because it illustrates her point that drunk drivers who kill can and have been and should more often be punished as second-degree murderers. Instead, some of them are punished with a lesser offense, such as involuntary manslaughter, which is punished much less severely than second-degree murder. And tragically, some drunk drivers who kill escape punishment altogether. And Steinbock's view is that that is unjust. We should punish fairly, which means everyone who is convicted of the same offense should be punished in the same way. Okay, so today is day 2. Later this week, I will post my third video on Steinbock, and that will complete the discussion of this article. Remember, next week is spring break, and so I won't be posting a video again or coming to class until 2 weeks from tomorrow. Okay, so 2 weeks from today, I will post a video. That's a Monday. And 2 weeks from tomorrow, I'll be in the classroom. And by the way, I'll be in the classroom from now on for the rest of the semester. I was in the classroom both days last week, and I'll be in the classroom tomorrow morning. If you choose to watch my videos and read my lecture notes, that's fine. It's up to you. It's optional. And what I mean by that is that I don't have an attendance requirement. If you do come to class tomorrow, what we'll do is have a discussion, or perhaps you can ask me questions about the course material. So I'm going to be there for any students who choose to come and ask questions. Okay, so let's get back to Steinbock. I'm opening up my notebook to my lecture notes. I'm on page 4 of my lecture notes if you want to follow along. Now, what we've been doing, in effect, is going over this taxonomy of homicide. So just a quick review. You'll notice that I've got the definition of homicide at the top, in the top row. Underneath it, I make a distinction between criminal and non-criminal homicide. We will be focusing on the criminal type. Criminal homicide falls into two categories, murder and manslaughter. And what we did in the most recent lecture is I told you what murder is. What is it that distinguishes murder from manslaughter? Murder is, and remember, this is in the common law. This is not the law of any particular state, such as Texas. In fact, most states have modified the common law to one degree or another. So I'm giving you the traditional common law understanding of murder. Murder is the unlawful killing of a human being by another, that means another human being, with malice aforethought. Now, remember what I told you. Malice aforethought is a term that could easily be misunderstood. In fact, if you look at footnote 1 on page 3 of my lecture notes, I have a long quotation from two law professors, and they say that the term malice aforethought doesn't have even approximately the meaning that it has in the law. In other words, there's a gap between the way lawyers understand the term malice aforethought and the way a typical person would understand that term. So what varieties of malice aforethought are there? Some malice aforethought is express, and that's the kind where the person in question intends to kill. And not only intends to kill, but premeditates it. So this is often called premeditated intent to kill murder. And it's in category 1 on my taxonomy. See that numeral 1 at the very bottom over here where my finger is? That's category 1 on the diagram or on the taxonomy. That's premeditated intent to kill. And many states consider that first-degree murder. Now, there are also cases of murder which have malice aforethought, but the malice is implied or implicit rather than express or explicit. The malice is inferred from the behavior. And there are 3 types of this kind of implicit murder. And I've lumped them together under the heading second degree murder. Excuse me. I should have brought some water up here. The first type of second degree murder is called felony murder. And that's where you commit a homicide during the course of a felony, such as robbery or arson. The second type of second degree murder is the one that applies to drunk driving, and the one that Steinbock is concerned with. It's called depraved heart murder. There's no intent to kill. What there is an act of extreme recklessness, an act that is so reckless that it shows indifference to the value of human life, and it ends up killing somebody. And that, Steinbock says, is the case with some homicides that occur while a person is driving drunk. And third, there's the intent to do serious bodily injury type of second degree murder. This is where you do not intend to kill. You do intend to inflict serious bodily injury on somebody. Maybe you intended to shoot someone in the leg to disable him or her. But instead, your bullet went awry and you ended up killing the person. Or maybe you hit the leg and the person was not able to get to a hospital in time and bled to death. So this would be second degree murder rather than first degree murder. Now let's turn to manslaughter. Manslaughter is the second type of criminal homicide. And if you look at my notes on page 4, you can follow along. At the common law, or in common law, manslaughter is defined as, quote, the unlawful killing of another human being without malice aforethought. Without malice aforethought, either express or implied. There's simply no malice aforethought in cases of manslaughter. Now, according to Lefebvre and Scott, the two law professors that I quoted a moment ago, or whom I mentioned a moment ago, manslaughter is really a catch-all category. They say that it includes homicides which are not bad enough to be murder, but which are too bad to be no crime whatever. So it's a kind of a middle ground between murder and no crime at all, or perhaps something like negligent homicide. And it's important to remember that there are two kinds of manslaughter, voluntary and involuntary. So let's take a look at each type, and I'll give examples as we go. Voluntary manslaughter is where there's an intent to kill, but the intent is not premeditated. Someone forms an intent in the spur of the moment. The person who committed the homicide didn't plan it beforehand. There's no premeditation, no forethought, if you will. And cases like this occur when someone, for example, flies into a rage and kills someone. The classic example is where someone comes home and unexpectedly and finds his or her spouse in the act of intercourse, sexual intercourse with someone else. The person who comes home may fly into a rage and kill one or both of the parties. Now, this is sometimes called heat of passion homicide, and it's a case of voluntary manslaughter. So there is an intent to kill. When the person pulls out a gun and shoots one or both of the parties, it's an intentional act. It's not accidental. It was part of a plan to cause life, but the plan wasn't premeditated. Right? The intention was formed instantaneously rather than over a period of time leading up to the killing. It's often said that the parties who are having sex are flagrante delicto, which means in the very act of committing the crime. In this case, it would be something like adultery. So that would be an example. It's not the only kind of voluntary manslaughter, but it's a classic example. Notice it's intentional, but not premeditated, and that's why it's not murder. If you look now on page 5 at the top, you'll see some examples of involuntary manslaughter. Here, there's not only no premeditation, but there's no intent to kill either. Okay? So the difference between voluntary manslaughter and involuntary manslaughter is intent to kill. Okay? With voluntary manslaughter, there is intent to kill. With involuntary manslaughter, there's no intent to kill. The killing is an accident. It's not planned. It's not intentional. Something went awry and someone ended up dying. So here are some examples. Negligent use of firearms. Suppose you are swinging a handgun around. Maybe you don't even know that it's loaded, and it goes off and it ends up killing someone. That would be homicide. It's criminal homicide, and specifically, it's negligent homicide. You were careless in your behavior, and someone ended up dead as a result of it. Other examples, negligent or unlawful operation of an automobile. So suppose you're driving in a careless way, you're looking at your cell phone while driving, and you end up striking and killing a pedestrian or a bicyclist. That would probably be prosecuted as involuntary manslaughter. What if you omit to furnish medical care for someone who is helpless or sick or injured, and you have a duty of care? I'm assuming that you have some special relationship with the person who is ill or injured. You're a doctor, for example. the patient's doctor or physician assistant or nurse. You have a duty under the law to care for your patients. And if through negligence you allow your patients to die, you could be charged with involuntary manslaughter. Another example, suppose you own a business, a place of entertainment, for example, and you allow it to be overcrowded. Now, the cities usually regulate the maximum occupancy of a restaurant or some other place. If you allow more patrons in than the law allows, and let's say a fire occurs, and because the place is overcrowded, not everybody can get out, and some of them die, you, as the owner of the establishment, can be charged with involuntary manslaughter. Notice you had no intent to kill, and it certainly wasn't premeditated, therefore, but you were negligent. You should have paid attention to how many people were there. You should have had rules in place to ensure that not too many people came into your establishment. And finally, conducting dangerous blasting operations on your property. Again, you have no intent to kill, but if because of the dangerousness of your activity, someone ends up dying, you can be charged with involuntary manslaughter. And typically, involuntary manslaughter is punished less than voluntary manslaughter. So if you're in category, look at my taxonomy, if you're in category 6, you will typically be punished less than if you were in category 5. And if you are in category 5, you will typically be punished less than if you were in categories 2, 3, or 4. And if you're in categories 2, 3, or 4, which is second-degree murder, you will typically be punished less than if you were in category 1. So from left to right on this taxonomy, the punishment decreases as you go from left to right. In fact, if you're in category 7, you won't be punished at all. The law says that while you did kill someone, you have a perfect justification for doing so, either self-defense or necessity or killing an escaping felon. If you're a police officer, killing someone in a just war, a combatant in a just war, or if you're an agent of the state and you're putting to death someone who's been duly convicted of a capital crime for which the punishment is, by definition, death. So, from left to right, you go from extreme punishment all the way to no punishment at all. Now, drunk drivers who commit homicide are usually, traditionally, charged with involuntary manslaughter. Steinbock objects to that. We should not punish them under that heading as category 6. They should be punished according to category 3. They have a depraved heart because they drove in full awareness of the fact that they had driven drunk before, and nonetheless they got behind the wheel and drove again. And this time, unlike previous times perhaps, they ended up killing someone. That is depraved heart murder, according to Steinbock. And as such, it should be punished as depraved heart murder. So Steinbock wants these cases of drunk driving where someone ends up dead to be prosecuted as second-degree murder rather than as involuntary manslaughter. And the punishment, of course, would be much greater. So let's turn to another topic. It's on page 5. What would constitute evidence of malice? Well, malice is a function of two things: the degree of risk that your behavior imposes on others, and the social utility of your behavior. So we could say this: other things being equal, the greater the degree of risk that you impose on other people, the more malice you display. Malice means malevolence. It means that you are acting with an ill will or a bad heart. You're malicious. Your behavior is malicious. And so the greater the degree of risk, the more malice your behavior displays or shows. As far as social utility goes, the less social utility your act has, the greater your malice. So in the ideal case of malice, the social utility of your behavior is very low, and the degree of risk that you're imposing on people is very high. That would show the greatest degree of malice possible. Conversely, if the social utility of your behavior is high and the degree of risk that you're imposing on others is low, your behavior displays little or no malice. You see how that works? It's a twofold. We could say malice is a function of two different things, degree of risk and social utility. So we need to ask, if we're to determine the malice of a drunk driver who kills, we need to ask two questions. How much risk is being imposed when you drive drunk? And how much social utility is there in driving drunk? Now be careful, because we're not talking about the social utility of driving per se. We're talking about the social utility of driving while drunk, and that's different. Driving, according to Steinbock, has social utility. Anyone who drives knows that. I drive for a lot of legitimate reasons. I drive to get to campus twice a week, and then I drive home from there. I drive to various shopping centers or locations so I can buy groceries, dog food, and other necessary items. I drive perhaps for entertainment. I drive to a movie theater or to visit someone. So driving does indeed have social utility. It has individual utility, and socially speaking, it has utility as well. But drunk driving has no utility whatsoever. In fact, here is a fallacy that might be committed, and we should avoid committing it and point out when other people commit it. Imagine somebody saying, driving has social utility, therefore drunk driving has social utility. Well, that's fallacious. It's true that driving has social utility, but it's false that drunk driving has social utility. And that shows you right there that it's an invalid inference. It has a true premise and a false conclusion. And that violates the definition of a valid argument. It shows you that this is invalid reasoning or fallacious reasoning. Now, this fallacy was pointed out long ago, as long ago as the ancient world. Here is the Greek philosopher Plato in his famous book, The Republic. Plato said that while it's true that one ought to return objects to their owners, it's false that one ought to return a weapon to its deranged owner. So imagine that I lent a weapon, a firearm or an axe or a knife. Suppose I lent a weapon to someone who seemed normal to me, psychologically normal. Now, that person, suppose someone borrows my weapon, and when I lend the weapon to that person, the person seemed psychologically normal. Now, actually, I still don't have the example right. Suppose someone lends me a weapon that I use. The time comes for me to return the weapon to the owner. But I notice when I go to the owner's house that the owner isn't acting normally. The owner seems deranged. Ordinarily, I have a duty to give the weapon back. But if the owner is deranged, I shouldn't give it back. So this would be an invalid inference. In general, it's true that you ought to return objects to their owners. But it's false that you ought to return weapons, which are dangerous, to people who are deranged, people who are not their normal selves. So this is often called the fallacy of accident. And it seems to me to be what Steinbock is saying. Don't confuse the utility of driving with the utility of drunk driving. That would be to commit this fallacy. Now, on page 6 of my lecture notes, you can see that the fallacy can be turned around, and it's still a fallacy. It's called the fallacy of converse accident. It goes like this. Drunk driving has no social utility. True. Therefore, driving has no social utility. Well, we know that's false. So that cannot be a valid inference. And you can see Plato's version of that as well on the page. So the point that Steinbock is making here is that when we evaluate the utility and the risk of drunk driving, we need to focus on the fact that it's drunk driving, not the fact that it's driving. Driving is admittedly inherently dangerous, but we allow it anyway because of the social utility of it. But drunk driving, according to Steinbock, has it's even more inherently dangerous, and it has no social utility. So if someone, while drunk driving, ends up killing someone, we could say that reflects malice. It has the two things that malice is a function of: high degree of risk, low social utility. What about repeat offenders? There are people who drive while drunk on more than one occasion. Often they drive while drunk and end up not harming anybody. We could say that that's just good luck for the driver, right? The driver happens to make it home safely while drunk. We can easily imagine things having worked out differently. Someone may have been walking in front of that driver, and because the driver was drunk, he or she may not have been able to stop in time and may have ended up killing the pedestrian. So repeat offenders really are on notice of their recklessness. People who regularly drive after drinking, people who have driven while drunk on more than one occasion, should be on notice, should be aware that when they go out drinking, they will once again get behind the wheel and end up driving drunk. And if on one of those occasions they end up killing someone, we can say that their act was reckless. It was reckless getting into the car, having drank alcohol. If you routinely drink and then drive, you need, in order to be responsible, you need to make alternative arrangements so that you don't get behind the wheel. You can have a friend who hasn't been drinking drive you home. These days, you could call it an Uber or Lyft. These are companies, as you know, who arrange to have people driven various places for a fee. So back in the day when I was your age, there was no such thing as Uber or Lyft or any other company like that. So you could, I suppose, call a taxi cab, to come and get you and drive you home. But maybe there was no taxi cab in that particular area. A small town, for example. I grew up in a small town in Michigan, rural Michigan. I don't even know whether there were taxis in that town. I think there were not. I don't think there were any taxis. So if you went to a bar and got drunk, the only way you could get home would be to call a friend or family member to come to the bar, pick you up, and drive you home. You could possibly ask someone else in the bar who hadn't been drinking, would you please drive me home? Maybe you could offer to pay that person to do so. You could talk to the bartender or owner and say, look, I really don't want to drive. I've had too much to drink. Could you find a way to get me home, and I'll compensate you for it? But nowadays, it's very easy to arrange a ride. You can call Uber, or you get on your app on your cell phone and have someone pick you up and drive you home. You can leave your vehicle parked in the parking lot of the tavern or bar. So when Steinbock wrote this article back in the mid-'80s, there was no such thing as Uber at that time. I think what she would say is all the more irresponsible for someone today to drink and then get in his or her car and drive it. That is even more irresponsible now than it was in the mid-'80s when things were more difficult, where it was more difficult to find a way home. Steinbock suggests that in drunk driving cases where someone has been killed, the trial itself can be divided into two stages to avoid any kind of bias on the part of the jury. The first stage would be simply to establish whether the defendant drove while intoxicated and killed someone. That would be the task of the jury in that first stage. Just determine whether there was drunk driving and as a result of that, someone was killed. And then you could have a second stage, either with the same jury or even a new jury made up of different people. You could look into the question of whether the defendant's conduct manifested extreme indifference to human life. Just set that off as a separate issue to be determined. And only if those two issues both came back affirmative would the person be charged with second-degree murder, because then it would fall in the depraved heart category, which is category 3 on the taxonomy. And the judge would sentence accordingly. Now, what if the jury found in the first stage of the trial, what if the jury found that yes, you had driven while drunk, and secondly, you had killed someone? If in the second stage, the second jury determined that your conduct did not manifest extreme indifference to human life, then perhaps you would be charged with involuntary manslaughter, which is category 6 on the taxonomy. So that would be an interesting approach Steinbock is suggesting, a two-stage trial to determine whether you should be punished as a second-degree murderer or as someone who has committed involuntary manslaughter. Okay, the final item in the first section is an actual case. I mentioned earlier today that I posted Edwards versus State, that Tennessee Supreme Court case, and I simply put a note in the lecture notes to have you read that case. Now, the note actually says read and discuss it, but I'm going to skip that. If you want to read it, you're free to do so. Again, I won't ask you any questions about it on the exam. Okay, we have another full class period on this article, so let me say a few more words about section 2, and then we probably won't need to get through the whole of it, but whatever we haven't covered, we'll finish up later this week in my second lecture of the week, my third and final lecture on Steinbock. Section 2 of her article is entitled Intoxication and Culpability. And in this article, Steinbock is going to reply to an objection that someone might make to her argument. The objection goes something like this. Imagine someone saying to Steinbock, Steinbock, these people are drunk, and isn't drunkenness or intoxication a mitigation? Doesn't it lessen a person's culpability when that person does something while intoxicated? So, according to Steinbock, on page 278, she is going to examine, and I'm quoting her now, she's going to examine the argument that since drunk drivers who cause death are often alcoholics who cannot help drinking, it's unfair to hold them responsible and punish them for doing what they cannot control, unquote. So that's the argument. Someone might say, Steinbock, at least some of the people who drive while drunk are alcoholics. And alcoholics, by definition, cannot control their behavior. So how can we punish the drunk drivers who end up killing as second-degree murderers when they're alcoholics. Now, maybe not all of them are alcoholics, but those who are, we perhaps should not punish on the ground that they lack control. They're compelled to drink. And maybe you can start to see why Steinbock considers this a bad argument. What exactly is the compulsion involved in alcoholism? The compulsion, she says, is to drink. She's admitting, for the sake of argument, that alcoholics are compelled to drink alcohol. But that's different from being compelled to drink and drive. Nobody, she says, is compelled to drink and drive. Even if you're compelled to drink, that doesn't mean you're compelled to drink and drive. And therefore, this is a bad argument. Even people who are alcoholics are not drunk all the time. They have bouts of drunkenness. Maybe they get drunk every day. They get up in the morning, perhaps with a hangover from the previous night's drinking. They get up, they're sober for a while, they start drinking again, and by evening they're drunk. They go to sleep. Maybe they wake up lucid or sober, whatever you want to call it. They start drinking again. It's during those lucid or sober moments when the person in question is responsible. And the responsibility means knowing what you had done and what you are likely to do again, which is to get drunk and drive. It's during those lucid or sober moments when you must decide what to do to prevent yourself from driving while drunk. You need to make arrangements with someone to take you home. You need to ensure that you don't get behind the wheel of a car by giving someone your keys the moment you take your first drink of the day. You don't even have keys, so you can't possibly get behind the wheel. Or maybe you can call an Uber driver and make an appointment. I need to be picked up at such and such an establishment at midnight tonight and driven to my home. You could even make arrangements to pay at the time you make the appointment. So all you have to do is be out by the door at midnight, you get taken home. That would be the responsible thing to do, according to Steinbock. So Steinbock begins her discussion of culpability. And by the way, culpability means blameworthiness. Have you ever heard somebody say mea culpa? That's Latin for my fault, or I'm to blame. I take responsibility. I'm culpable, you're saying. So the question is here that we're now discussing is, to what degree are drunk drivers blameworthy or culpable for their conduct? So Steinbock begins her discussion by pointing out that sometimes involuntary intoxication is an excuse for criminal behavior. So suppose you are in a bar and you're drinking lemonade or a soft drink. Somebody puts something in your drink when you're not looking. You drink it thinking that it's just lemonade. In fact, whatever was put in your drink intoxicated you. And you then got into your vehicle and drove. You had no reason to think that you would be driving while intoxicated. In fact, it was your plan not to be intoxicated. Your intoxication is involuntary or against your will. If you were charged with an offense for drunk driving, you could argue at trial that because your intoxication was involuntary, you were not responsible for your behavior, or not fully responsible, and shouldn't be punished to the full degree or to the same degree. So Steinbock points out by saying involuntary intoxication is a defense. But voluntary intoxication is rarely, if ever, an excuse or defense to a criminal charge. If, if you were drunk while doing something, operating a chainsaw, for example, and you injured someone and were charged with a crime for doing so, you would not be able to raise intoxication as an excuse for your behavior. If anything, the fact that you were operating a chainsaw while voluntarily intoxicated makes it worse rather than better from your point of view. It's called an aggravating factor, which means make something that makes it worse, rather than a mitigating factor, which means something that makes it less bad. So, 2 points Steinbock is making. Involuntary intoxication is typically considered a mitigating factor, an excuse, a defense to a charge. Voluntary intoxication is rarely, if ever, an excuse, and sometimes it's an aggravating factor. That means you were doing something dangerous, such as operating a chainsaw, and to make it even more dangerous, you were drinking while operating it, right? Voluntarily consuming alcohol or some other intoxicating substance. So here is an argument that someone might make against punishing drunk drivers who kill as second-degree murderers. I call it the argument from addiction. And you can see it's a chain argument like the other ones we've seen recently. It has more than one conclusion, but it culminates in what we might call a grand conclusion. Here's how it goes. Now imagine somebody having read Steinbock's article and making this argument. The person says, Dr. Steinbock, those who are addicted to alcohol do not voluntarily drink. They're compelled to do so. That's what it means to be an alcoholic. You're addicted to alcohol and you've lost self-control. You act under compulsion rather than voluntary free will. Second point, some drunk drivers are in fact addicted to alcohol. It doesn't matter what percentage, but surely at least one person who drives while drunk and kills is an addict, an alcoholic. What do you get when you put these two premises together? You get proposition 3. Some drunk drivers, namely those who are addicted, do not voluntarily drink. Right? So the critic thinks he or she has established that now. On the basis of 1 and 2, 3, the critic says, has been established. Some drunk drivers, the ones who are addicted to alcohol, do not voluntarily drink. Now, let's add a new premise and keep going. A drunk driver, we might say, is culpable only if he or she voluntarily drinks. That sounds plausible, but we'll come back to it in a moment. Put 3 and 4 together. A drunk driver is culpable only if he or she voluntarily drinks. 3 says some drunk drivers do not voluntarily drink. What follows from 3 and 4? Turn the page and you get this. Some drunk drivers, namely those who are addicted to alcohol, are not culpable. And if a drunk driver is not culpable, then he or she should not be punished. We punish only those who are blameworthy or culpable. And we should not punish those who are not culpable. Now, what does Steinbock say about this argument? If you look at my page 8, you'll see some of the things she might say about it. First of all, she might point out, just to start off, that the argument covers only some drunk drivers who kill. Which ones? Those who are addicted to alcohol. Presumably, not all the people who drive while drunk are alcoholics. Some are not. The argument we just went over applies only to those who are alcoholics, because only the alcoholics are compelled to drink. So that has the effect of shrinking the applicability of this argument. The conclusion applies only to a small percentage of drunk drivers, those who are alcoholics. But Steinbock has a bigger problem with this argument than that. If you look at my second point, it says the fourth premise is false. Steinbock, I think, would accept premise 1 and premise 2 of the critic's argument. And I think she would probably focus on proposition 4, which is also a premise, to criticize. She would say that what makes the drunk driver culpable is not the drinking, but the drinking and driving. Right? It's a point we made a few minutes ago before we got to this argument. Hence, a drunk driver can be culpable even though he or she does not voluntarily drink. The culpability comes in earlier, when you were sober or lucid. That's when you failed to take precautions against driving while drunk. So it's as though you're like a werewolf. If you know that in the evening you're going to turn into a werewolf and damage people, harm people, by all means you need to see to it that you are confined so that when you become a werewolf, you can't do any harm to anybody. Okay, it all comes down to your knowledge of what is likely to happen when you start drinking alcohol or when you become a werewolf. So Steinbock rejects premise 4. Premise 4 says a drunk driver is culpable only if he or she voluntarily drinks. Steinbock is saying, in effect, that a person is culpable even if he or she voluntarily drinks, because the culpability occurs before you take the first drink. It's when you are lucid or sober. That's when the important decisions must be made. Now, there could be someone who is an alcoholic and is completely irrational about it. Someone who can't think clearly. Maybe the alcoholism has so damaged the person's mind that he or she never has lucid moments and never understands the routine. I get up in the morning and then at some point during the day I start drinking and I end up at the bar, I end up getting in my car and driving home. Maybe your brain is so damaged from drinking that you can't even, you don't even have those lucid moments. At that point, society needs to step in and incapacitate you. If you can't be deterred, if you're incapable of even thinking through what you're doing, then you need to be treated like a dangerous animal. We don't reason with rabid dogs. We take steps to see to it that they can't possibly bite anyone. Right? We confine them or put them to death, or both. We confine them for a while until we find out whether they're rabid, and if we find out they are, we put them to death. So Steinbock says if there are cases like that, then punishment is not appropriate. Some kind of institutionalization or incapacitation is called for. So we should be, all of us should be vigilant when we observe people drinking, or if we know someone, a friend or a family member or an acquaintance. If you know of somebody who is driving while drunk on a repeated basis and the person is incapable of thinking it through, we need to call the authorities. There needs to be an intervention by some public official to get that person treatment, or at a minimum, confine the person until a proper decision can be made about what to do. What about the argument, and maybe this occurred to some of you, what about the argument that people have to drive? Driving is essential for almost everyone, We all need to get around, to go to work, to go shopping, to go to the doctor, and to keep other appointments that are important. Um, Driving is a fact of life, and for many of us, it's a necessity. In fact, there are people who live in places that lack public transportation. No buses, there may be no subways, buses, limousines, and so on. Now, things have changed a little bit since this article was published. I pointed out a few minutes ago that we now have Uber and Lyft. I grew up in a small town in Michigan. I've told you that a couple of times. And I don't know, to be honest, whether Uber operates there, but I think it could and probably does. It may be a small town, but there are probably people who have signed up with Uber or Lyft and who are willing to go pick someone up and drive him or her to the grocery store or to a doctor's office or something like that. So the argument that we're now considering in some ways has become moot as a result of these new technologies and new services. But let's go back in time. There's no bus service in my little town. I know that. There wasn't then, and to my knowledge, there is not now. It's just too small. No bus service could make a profit. And there are no taxi cabs, as far as I know. There's no subway, no train. Everyone gets around in a private vehicle. So what about this argument that people in that small town need to drive? Steinbock says it is true that for many or most people, maybe even all people in a small town, driving is a necessity. And it would be a great inconvenience for people to find an alternative way to get around, to have a friend drive you into town to get groceries once a week, let's say, or to have a family member take off work to drive you to an appointment in town or to a neighboring town. Yes, that's inconvenient. It's inconvenient for you. It's inconvenient for those who have to drive you. But Steinbock is saying on page 290, that's a mere inconvenience. And, well, let's read what she says. It's not unreasonable to require people to undergo great inconvenience to avoid killing other people. I mean, it's a balance. Yes, it's inconvenient to expect people to make alternative arrangements other than driving their own vehicle. But we're talking about life and death. Better to inconvenience people who might otherwise drive while drunk than it is to end someone's life or horribly mangle and injure somebody. So we've got a balancing taking place here. Better inconvenience than injury or death. It's not unreasonable to expect people to make alternative arrangements. They might want to drive, but that's irrelevant. Society should say to them, too bad. I know you like to drive your car. You'd like for your own convenience to drive to the bar and then drive home when you're done. But you can't. It's too risky. And we expect you to make alternative arrangements at whatever inconvenience that may be to you. Because the alternative is imposing a great risk on innocent people whom you may kill or injure while driving drunk. Now, I put a little note in my lecture notes to discuss what I call the infatuation with automobiles. And how does that bear on Steinbock's argument? Someone might be reluctant to accept Steinbock's argument on the ground that automobiles are too important to us to take them away from people. Now, no one's suggesting taking cars away from people. What Steinbock is suggesting is depriving people of the right to drive while drunk. And that clashes with frankly, the love affair people have with automobiles. What do automobiles signify in our culture? I compiled a list. Automobiles are associated with power, right? There are people who love to drive, and they like what are called muscle cars. They love to get behind the wheel of a powerful automobile and push on the gas and drive very fast down a road, down a highway, for example. Some people like the feeling of accelerating, right? Which is why people spin their wheels. They do burnouts. They love the high acceleration in fact, you hear this, what is it called? A car goes from 0 to 60 in half a second, or I don't know, 1 second, whatever it is. Right? A lot of people like that feeling of power and thrust. And they like cars for that reason, the feeling of power that it gives them. Also, people like driving because it gives them a feeling of control. People like driving on winding roads because they have to use the steering wheel. You like my little mimicry? People like that feeling of being in control of a powerful vehicle. I suppose it's like the feeling of riding a horse in the olden days or even today. A horse is a powerful animal, and a skilled rider must feel as though that horse responds to every movement of the legs and the bridle pulling on it and the voice. Being a skilled rider of a horse, a skilled equestrian must feel, and I say must because I'm not an equestrian. I may have ridden horses when I was a kid, but it's been a long time. I don't even remember what it was like, although I think I was afraid. But a skilled equestrian feels a sense of power and control being on that animal. Also, speed, I mentioned earlier, power, speed, authority. When you're behind the wheel of a vehicle, you alone are in control of it. You are the authority. No one is bossing you around, telling you what to do. There are what we call backseat drivers. We don't like that. I don't want you telling me how to drive. I'm in control, not you. Right? So keep your mouth shut and let me drive the car. Let me handle things. It gives people a feeling of independence. If you've got a car, do you remember what it felt like when you got your first car? Having been dependent on your parents for many things, finally, you reach that moment where you can get into a car and go somewhere. You can go to your friend's house or go to a sporting event, whatever. You're no longer dependent on others to drive you around. The automobile signifies a kind of independence in the same way that a horse must have in the olden days. It gives people a feeling of mobility. I'm mobile. I can move about freely. I can go short distances, long distances, wherever. That's an important fact of life for many people, being mobile. No one wants to be immobilized, stuck at home with no way to get out, short of asking someone for assistance. Freedom, which is related to mobility. A car signifies freedom or liberty to come and go as you please, to see the world, to move about. Maybe cars even signify masculinity, right? Depending on what you encompass within the concept of masculinity, you have a feeling of powerfulness, right? A feeling of strength, authority. Maybe all of those things we talked about already are part of the concept of masculinity. I don't know, I haven't seen any studies, but I suspect that, and this is just a guess, that the majority, maybe the vast majority of people who love cars are male rather than female. That's not to suggest that all men like cars or love cars. I'm not saying that, or that no women do. But in terms of percentages, Driving a vehicle may be more of a manly or masculine thing. A car is sometimes associated with success, and that, of course, will depend on what kind of car you're driving. If you watch advertisements on television, some cars give off an aura of wealth and power. The Cadillac, for example, when I grew up, and maybe to this day, Cadillac was the mark of excellence in an automobile. Everyone knew that they were expensive. They cost more than a typical car, like a Chevy or a Ford or a Toyota. The Cadillac's not for everyone. Only those people who can afford it can drive a Cadillac. And other people who see them go by look at them with a certain envy. Oh my goodness, look at that beautiful, shiny Cadillac. I wish I could afford one. In fact, I grew up hearing people say, back when the price of gas went up in the late 70s, higher than we were used to, people used to laugh at Cadillac owners because they were not as fuel efficient as other cars, smaller cars. And the response was, if you can afford a Cadillac, you don't worry about the price of gas. Right? If you're wealthy enough to afford to own and drive a Cadillac, the fact that gas costs a few cents more is no concern to you, of no concern. So, some cars are status symbols, and people love them for that reason. Right? They want to show off their success in life. I've got a good job, I make a lot of money, and I want people to know that. And one way I can broadcast it to the world is in the car I drive. Some people call this conspicuous consumption. Right? You're consuming, in this case, by buying a certain car, and you want it to be conspicuous. You want everyone to see what you're consuming or buying. And the car, some people identify with their cars. Right? The car is an extension of the self. If you think of yourself as powerful, successful, you will want a car that also has those traits. Right? A muscle car may go perfectly in hand with someone who feels muscular, strong, successful, perhaps wealthy. Some people want a fuel-efficient car. They want to have a small footprint in the way they live their lives. So they want to be frugal. They want a car that gets good gas mileage. And a lot of people today want an electric vehicle for that reason. They want a car that does not make use of fossil fuels. So anyway, I like to discuss the significance of automobiles in our culture. We are, I think it's fair to say, an automobile worshiping culture. And that may be part of the reason why people are reluctant to make alternative arrangements to get home from a bar or tavern or pub. It feels like it feels emasculating. No, damn it. I can drive. I can drive to the bar and I'll drive home. Thank you. I don't need an Uber or a friend to drive me home. So there's a kind of stubbornness rooted in the love affair with the car that leads people to insist upon driving while drunk. And I think Steinbock would say that needs to change. That attitude needs to change. Lives are at stake. And we need to make sure people understand that. There's no shame in having someone drive you home if you've gotten tipsy or if you're drunk. No shame whatsoever. We need to remove the stigma of having other people drive you home from a bar, let's say, or a sporting event, someplace where you have gotten drunk. Okay, let's pick up with part 3 of Steinbock's article 2 days from now. I plan on recording the lecture Wednesday, and I will post it that very day. And if anybody comes to class on Thursday, We'll discuss aspects of it. You can ask questions about it, whatever you'd like. But again, it's optional. I will be there, guaranteed. Whether you come is up to you. Okay, we have gone an hour and 5 minutes, which is about what I expected. And I think I've left, I think we've gotten far enough so that we can finish the article on Wednesday, 2 days from now. Have a great day and have a great tomorrow, and I'll see you in a couple of days.